Yes, Sir James.
My Lords, good afternoon. 4 starting points and 5 submissions, if I may, 9 in total. The 4 starting points are these. Firstly, the regulations in question are incompatible with the ECHR in the respects identified by the Supreme Court in Carmichael/MA/Rutherford. And you've already seen that. It's behind tab 11 in bundle 1 at page 589. And you were taken this morning by Mr. Drabble to paragraphs 41 to 49 in particular, pages 606 to 607 in the judgment of Lord Toulson. I'd invite you to go back to those now unless you want to. Our submission is that the Supreme Court in that case held, relevantly, that there was no justification for the difference between the adult's position and the position of a child who cannot share a bedroom because of disabilities. The child's situation under the regulations at that time, following the legislative amendment post the Burnip case, allowed for that. So there was in fact entitlement in the context of children to 2 bedrooms. But it didn't allow for that in the context of adults. And so there was, in consequence, under-occupation in some houses and a reduction in entitlement by the use of the percentages that we've seen. And the clear effect of the legislation at that time was that adults were not covered in relevant part. It was that which led, in effect, to there being, on the court's analysis, no rational justification for children being covered and adults not.
That wasn't the only respect in which the regulations were held incompatible. It was also in respect of those children who needed an extra bedroom for a carer, as well as adults who did.
My lady, it was. I think.
I know that's not this case, but
yes,
but nevertheless, it's important to bear in mind that it wasn't purely inconsistency in the way that had been remedied after Gorrie. It was the other respect as well.
It wasn't. My lady's exactly right. I was simply going to take the adult versus children sharing rooms, because I don't think anyone suggests that that distinction makes any difference to the issues that this court is confronting here. But my lady's exactly right. That was the ironic position that Lord Thomas identified with our position. It was the flip side. But my lady's entirely right. But the ratio of the case, so far as we are concerned, and restricting it to the example I've given, was that the scheme inexplicably, effectively, made provision for Burnip/Gorrie cases, but not the Carmichael-Rutherford counterparts. It was akin, if you will, to an irrationality finding. There's no basis for that distinction, holds the court. The court did not find that giving effect to the bedroom tax, as the appellants call it, violates the rights of individuals with transparent medical need for an additional bedroom. Indeed, they specifically didn't decide that, because that explains the difference between the cases in which discrimination was found and those where it wasn't. The finding was limited in the manner that I've indicated, and the freestanding MA claims were which were based upon a failure to make provision on the grounds of need, failed. And they failed, in essence, as you've seen from the judgment, because of the existence of the scheme of DHPs, which was considered to be an appropriate parliamentary solution. And therefore, that scheme was justified rather than setting up hard-lined rules within the regulations themselves. But that didn't work, as I say, for the particular categories that we were concerned with, for the reasons I've given. So that's the first starting point. Second starting point is that the regulations cannot be interpreted under Section 3 of the Human Rights Act in a way that avoids incompatibility. And it's at least worth pausing there to see why that is. That, we submit, is because the scheme makes clear provision for the calculation of entitlement, including reduction and specific exceptions. It's clear how Parliament intended it to work, and no one seeks to defend the approach of the FTT here, which was in effect to rewrite the size criteria by adding words in effect, additional wording being inserted. No one seeks to defend that. And it's never been suggested, I'll come back to this point, but it's never been suggested in any case that the percentage reduction itself as a mechanism is unlawful. It simply forms part of the overall statutory scheme and is the mechanism by which the regulations that we're considering give effect to the size criteria. The challenge in every case, in substance, has been to those size criteria. Why, if children who can't share are entitled to an extra room, does the same not apply to adults? It's adding in that category, that's the nature of it. But it's clear and common ground that Section 3 of the HRA cannot avoid the incompatibility. And the reason for that is because Section 3, and it's a constant theme, as this court has regularly noted, that runs through the Human Rights Act, draws a pretty clear constitutional boundary between that which can properly be said to be interpretation, a possible interpretation on the one hand, appropriate for the courts to do, and straying onto the other side of the line, that which it would not be appropriate for the courts to do because it would amount to judicial legislation. That's the second starting point. The third is that the problem that was identified by the Supreme Court in the Carmichael case, focusing on the adult versus children sharing position, was not simply a problem which in nature involved compatible legislation with unlawful decision-making made under it. The incompatibility was not the result of primary legislation. It wasn't compelled by the primary legislation, and I therefore make no case under Section 6.2 of the HRA. But nevertheless, the legislative solution that was needed was a structural legislative solution in order to correct the discrimination found by the court, in the light of the fact that the powers of the court under Section 3 could not do that, because it would amount to judicial legislation and not judicial interpretation. So to rectify the incompatibility identified or declared required or would require the amendment of the scheme, of the legislative scheme. The fourth starting point is that there are, and there have since the court declared the discrimination and found the discrimination in the way that it did, there are a variety of ways in which that might have been done so as to secure compatibility, raising choices as to how that should be done. And that, we submit, is reflected in the remedy that the Supreme Court ultimately ended up with in that case, which was declaratory only. And I think my lady asked, how do we get there? Asked Mr. Drabble, how do we get there? And I think the answer to that is you have to go back from what the Supreme Court say in their judgment to the orders that were made in the Court of Appeal, which effectively, when the appeal was dismissed, stayed in place. And they were declaratory, as I understand it. We can give you page reference if we can find them.
No, I did secure a copy of the order, which I have now.
Oh, well, I'm grateful. I don't think it was in the bundles, was it?
No, that's why.
That's why you secured a copy of it.
But yes, you're quite right. Most of it was all about whether appeals were dismissed or allowed,
Yes.
and costs and so on. But in the case of the one that was allowed, it is declared that Jacqueline Carmichael has, as a result of the application to her of Regulation B13 of the Housing Benefit Regulations 2006, suffered discrimination contrary to Article 14 of the European Convention on Human Rights on the basis set out in the judgment of the court. So it was a declaration. And there was a similar declaration already made, I think.
Yes, that was my memory. I think my lady's therefore ahead of me because we thought I'd forgotten that order had been made by the Supreme Court. That's the one you have. And I'd gone back to the Court of Appeal and just simply traced it from the judgment. But it's the same. I suspect that declaration was almost exactly the declaration that the Court of Appeal had made. But I may be
Well, not in the Carmichael case. It will have been in the other one. Because we had to allow the appeal in Carmichael, which is why we made the declaration.
Yeah, well, I'm grateful. Anyway, my lady, a declaration is that's the only word I wanted.
That's the only word you wanted.
That's all I wanted, however arrived at. It was declaration. And the question, therefore, with those four starting points in mind, and against that, the backdrop of them, is whether or not the FTT, whether the logic of all of this flows through to the local authority as well, whether the FTT can make an award that effectively confers entitlement on individuals before the tribunal on a basis other than that which is either A, provided for under the regulations, or B, even a possible HRA interpretation of the regulations. Can they do that? That's the question which is raised by this appeal. And of course, there may be particular features of the particular way in which our regulations are drafted, but we do respectfully submit, for all the indication that some members of the court might have found this a tolerably easy decision, this first issue. This is an issue which has really significant ramifications for secondary legislation and for the way in which the Human Rights Act is meant to work in this sort of situation, characterised in particular by the existence of legislative choices and then a statutorily restricted tribunal administering a scheme of benefits. So that's the backdrop. And the first submission that we make is that until Parliament adopts a legislative solution, and the legislative solution that it chooses, the FTT must proceed on the basis that the entitlement, and it's there to deal with entitlements, is that in the unamended scheme.
When you say Parliament adopts, are we talking about negative resolution procedure SI or affirmative resolution procedure?
Which one this would be, but it would certainly involve one or both of negative or affirmative. Yeah. So affirmative when first put in, I'm told. We can find you the particular provision. But that's what I meant by Parliament. Of course, I recognise and understand that it's for the Secretary of State initially to design and then to present to Parliament with those varying degrees of parliamentary oversight. And the submission is therefore that until they do that, the FTT fulfilling its function has got to proceed on the basis it's there to deal with entitlements. It's got a statutory scheme. It must continue to apply that. And any sort of redesign of that legislative scheme to create a new entitlement would be, we respectfully submit, constitutionally inappropriate. Now, just go back for a moment to the HRA. I'm going to try very hard not to go back to the individual sections unless you want them there in the authorities bundle behind tab 1, but they were very familiar. The court or a tribunal, I'm going to break my rule immediately, but simply because I think Mr. Drabble said Section 8.1 only applied to courts, and it doesn't apply to courts and tribunals.
Yeah. I accept it applies to tribunals, but not to SEFTO, that's the point.
Just to show you that, so behind tab 1 in Authorities Bundle 1, MS 355 if you're on the electronics, and you see that court for the purpose of Section 8 in sub 6 includes tribunal. So the court or the tribunal has a remedial discretion under Section 8 in the event of unlawfulness under the HRA, and it deals, that's the HRA deals, specifically with how this remedial jurisdiction is to work. It arises, that Section 8 and the remedial discretion arises by definition where Section 3 HRA cannot be used, cannot work to fashion compatibility by interpretation of an otherwise incompatible scheme. the discretion to grant relief or remedy or make such order within its powers as it considers just and appropriate is in section 8.1. I make two submissions about the limitations in relation to 8.1. The first limitation I submit is within the phrase no power to do so beyond its existing powers. And that applies, of course, both to the FTT and also to courts.
Now, Sir James, you haven't looked so far at the opening words of Section 8 in relation to any act or proposed act of a public authority which the court finds is or would be unlawful. Now, as Mr. Chamberlain explained, you can have unlawfulness at a number of different levels. The tribunal itself is required by Section 6 not to act in a way which is unlawful by reason of being incompatible with the Convention. The Secretary of State has a duty. The SEFTM have duties. Section 8 doesn't apply to, the court.
Lawful acts.
Yes, the tribunal wouldn't be applying Section 8 necessarily in dealing with the problem in the present case. It would depend on which act it focused on, wouldn't it?
Well, it could depend on which act it focused on, but I fully accept that the remedial discretion under the Human Rights Act is preconditioned by unlawfulness under that. So if, for the sake of argument, you as the public authority under Section 6 were acting compelled by primary legislation, I use the phrase deliberately to bring our Section 6.2 outside arguable interpretations of that provision, but then you're not committing unlawfulness. And I also accept, of course, that public authorities can include both tribunals, courts, and standard public authorities such as the Secretary of State. So all of that is true. But what it doesn't do, this provision, is to expand the powers of the relevant body. It simply acknowledges the existence of the powers that they have. And that was a point that was expressly made by Lord Wilson, if you recall, in the T case, Authorities 2, tab 23, para 63 at page 1109 in the MS numbering. And you note also that in relation to tribunals, which is where the principal focus is, there is a power, a ministerial power conferred under the Act to expand the powers of a particular public authority or tribunal. If you look at 7.11, section 7, sub 11, which really goes to reinforce that point. They have the powers that they have for the moment. The Secretary of State or a minister can expand those powers if he wishes. That hasn't yet relevantly been done in relation to the FTT. And the FTT's powers are effectively to review or decide whether the decision maker reached the correct decision in law, applying the current legislative scheme we respectfully submit, not some other scheme fashioned by them.
So they disregard the fact that there's an incompatibility?
Well, my submission is going to be that until Parliament has fashioned the solution, it can find unlawfulness, but what it can't do is go to the next stage and say, as a result of that, you now have a new entitlement under a revised legislative scheme consequent upon the finding of that incompatibility. So they continue to have a function, and ultimately public authorities continue to be exposed, as it were, to claims for damages in appropriate cases, if it's a local authority, whatever it may be. But the difficult question here is not whether they can continue to act or whether this is, as it were, a charter to ignore findings of incompatibility that have been made, or even findings of unlawfulness that flow as a natural consequence of the Supreme Court considering a discrimination issue. It's the next question that's really important, we submit, and that is, what can a body like a tribunal, which is meant to be administering a legislative scheme, do about that? I mean, suppose, for the sake of argument, we'll come to the extent to which this is live or relevant here. We submit it is, but for reasons I'll come to. Suppose there was a scheme and there were 13 or 14 different ways in which compatibility could sensibly and realistically be achieved. Is it for the FTT to fashion which one of those, and they might have different financial consequences, which one of those is the right one?
So what's the status of this legislation in the meantime?
It continues as secondary legislation.
Right, with no flaw in it.
Well, it has the flaw that the Supreme Court have identified,
Yes.
and that may lead to decisions which are unlawful under the HRA.
But no flaw going to its status.
No flaw going to its status, because the right body to deal with those choices I'm going to submit is Parliament. And the more choices it has, the more obvious the constitutional difficulty of a body like the FTT or a fortiori, a local authority, deciding we're going to recast it in this way. We're going to select option 1 or option 2 or option 13, which may have different consequences. So,
were you going to say anything about the words "and given effect" in section 3?
well, my lady, I was tempted, but I'm going to resist the temptation.
Right.
I mean, I can address it. I'm not going to be saying that in some way, shape, or form, section 3 then allows you to say so far as possible, so you end up with lawfulness under this scheme. And that involves looking both at give effect in a way that in 3, which you focused on, and it involves focusing on similar words, which you will find in 6.2b. And of course, the consequence of 6.2b is to create lawfulness. But I think the government position for many years has been, per the Sales and Clement article, that 6.2b is where there is compulsion from primary legislation.
Yes.
And what that, therefore, if you take the give effect to words back into section 3, you then have to find a meaning for, if you will, a separate meaning, unless you go for the Chamberlain composite effect interpretation of that. You have to find a meaning of give effect to which is consistent with the interpretive role that section 3 on its face is designed to deal with.
But isn't section 3 also directed to people who actually implement legislation?
It is.
And that's why we have the words "and give effect." And so it's got a wider meaning than just interpretation by a court.
It has, and that is why maybe subordinate legislation is also included in 3.1, but not in 6.2b.
But then that's surely not a set of words then that would allow for lawfulness, but would allow for a limitation on lawfulness because of the opening words of the subsection. So far as possible, you give effect to legislation in a manner compatible. But if it's not possible, because it can't be interpreted.
Yes, my lady, I'm not suggesting that any of this dilemma, interpretive dilemma, 3.1 read with 6.2b is easy. And I fully see the force of that. If one simply focuses on 3.1, it does apply to subordinate legislation, and give effect to does suggest that it's doing something more than mere interpretation.
Right.
It's designed to control the actions of those who are sitting under. But as I say, when those two provisions are read together, the government's consistent position has been that it's only in the case of primary legislation that you end up with lawfulness if that's the result that is compelled.
Can I go back to where you were with regard to the subordinate legislation carrying on, having to be applied by the FTT?
Yes.
That makes a Human Rights Act incompatibility case different then from an ultra vires case, where if the subordinate legislation was ultra vires, leaving aside that, the tribunal couldn't apply it, could it?
My lady, I think the answer to that question is yes. It does make it different, and it reflects the overall constitutional balance that sits within the HRA.
But it makes it then doubly important to consider whether, in fact, the effect of Human Rights Act incompatibility is to render something ultra vires.
That's true. We don't have concepts of ultra vires in the legislation.
Not in the Human Rights Act.
Not in the
no.
Human Rights Act. And so it is a common law or public law remedial construct. That's the right way of putting it. My submission is going to be that under the Human Rights Act, Parliament has been assiduous to try to maintain the constitutional boundaries that run through most of these provisions. It's given particular elevated status to primary legislation. And we know that you can't do anything other than a Section 4 if you conclude that primary legislation is structurally incompatible. And we know that that means that it continues to operate even though the court has held it's incompatible, even though decisions being made under it may continue to be incompatible, pro tem, pending Parliament, dealing with it. We know that that's the position in relation to the Act. And the position in relation to secondary legislation is much more difficult and much more fuzzy under the Human Rights Act, if I can put it that way. We know we don't have those clear binary ways of looking at things, but it's equally clear, I respectfully submit, that you're likewise not automatically in the territory where just because you hold that secondary legislation is structurally incompatible, it necessarily falls or is to be struck down or is invalid or ultra vires in some looser sense of that word. My submission is that in that situation, when you're dealing with secondary legislation under the HRA, there are choices to be made by the court. And the choices to be made by the court are not unfamiliar. They are precisely the choices that you would have to make when you start considering other balances within the Act, other constitutional balances within the Act. Who is most appropriate to make this decision? Is there only one answer? If you have a provision which has, I don't know, a jurisdictional gateway which turns out to be incompatible, maybe slicing that through, disapplying it, severing it, whatever language you want to use, is fine. But it doesn't necessarily follow that just because you're in secondary and just because it's structural, you don't have to confront the choices as to whether it's appropriate for a court or a tribunal to decide what the solution should be, if that's what it has to do in order to get to a sum of money.
Where I'm struggling with this is in Section 6, because it seems to have two spelled out categories. One is primary legislation dictates it, therefore it won't be unlawful. One is primary legislation governs the subordinate legislation, therefore it won't be unlawful. But where there is no primary legislation-driven subordinate legislation, it's not there. And therefore it must be covered by 6.1, mustn't it?
And it continues to be unlawful until Parliament has sorted it. But the distinction is between unlawfulness, liability if you will, and remedy. And remedy under the scheme of this Act is dealt with in Section 8.
But the net result is that the court or decision maker who's a public authority has to act unlawfully.
They have to act unlawfully in that sense until Parliament has sorted the problem. But the Act creates remedial consequences for that. I'll come back to this point, but it creates remedial consequences, which is that it opens them up to liability for damages, continues to open them up for as long as that is the position, and if a court makes a declaration of incompatibility of secondary legislation and the court decides to do only that, as it were, on the basis that it can't interpret its way out, it's more appropriate for Parliament to address the solutions. How do you restructure the scheme in 13 or 14 different ways? At that point, the declaration has also had an effect under the Human Rights Act. It may not be a declaration under Section 4, but it's the court telling Parliament that this piece of secondary legislation is incompatible, and that provides a spur for them to change it. It doesn't trigger the subtlety of the remedial action provision that a Section 4 declaration of primary would do in Section 10, but it does provide the spur for Parliament to act. As I say, the remedial scheme, what are the consequences of unlawfulness under this Act, are set out in 8.
And in 7.
And in 7, bring proceedings.
No? 7, well, not only 7.1a, but 7.1b.
Yeah, but that, my lady, of course. And they can continue to do that. And the court may...
But you're saying that despite Section 7.1b, a claimant who is told by a public authority that they're not entitled to benefit at a certain level, that decision being unlawful by reason of Section 6.1, is not allowed to bring it up when they bring an appeal against that decision?
I'm not saying that. I'm saying that they can bring it up. They can bring it up, and the court can say, if it wants to say repeatedly, you are still, the legislation is still incompatible, and it follows.
Let's bring it up before the tribunal. They can rely on it. The unlawfulness of the act. What can rely mean other than get the tribunal to operate so as to remove the unlawfulness?
Well, they get there, but then that simply begs the question of what that means. What does that involve? And for that purpose, you go to Section 8.
No, you don't have to necessarily go to Section 8.
Well, my lady, my submission is that under this Act, you can rely on it. And the question is, what is the consequence?
Yes, that's
and the FTT is dealing with entitlements, administering a statutory scheme, and it's now in the position, because the Supreme Court has found incompatibility, where it's got to decide what to do about that. My lady says, well, just sort it out. But sort it out how is the question. And it's the how question that Section 8
There will be cases where it is really difficult to work out. I completely accept that.
My
But
lady,
in
well, then
this particular situation with which we are dealing, it's very easy to sort it out.
well, my lady, then at least step one of the argument we are entirely agreed about. And the only question really is how difficult or not. And my submission is, as you know, my submission is that when deciding how easy or difficult it is, that isn't just a linguistic exercise. That engages exactly the constitutional themes that run through the Human Rights Act.
But the court is only dealing with the instant case. It's not dealing with how the legislation should apply in future as a scheme. It's only dealing with this one case.
It is.
So it's simply got to be satisfied that granting the relief it intends to grant is appropriate in this instance.
But if that involves it deciding that a sum of money should be ordered to be paid, cut to the chase, this is about entitlement. This is about social security.
But it's not
money.
Yes.
I'm sorry, my lady.
No, I interrupted. I apologise.
No, I was about to say, this is about social security, entitlement and money. And if the existing legislative scheme doesn't work because it's incompatible, then the question is, on what basis does that money get ordered? And that may involve, often will involve, and in our case will involve, or does involve, asking the question, how do I know the answer to that question when I'm deciding what money should be awarded, unless and until the legislative scheme has been altered?
Well, but if a failure to award the money would be a breach of Article 14, then the court would be acting unlawfully in failing to award it. And courts can't act unlawfully.
The courts can't act unlawfully, but the question is whether the question is what money? How do you get to the sum of money is ultimately the question.
Well, it's to avoid discrimination. It would be the amount of money which the comparator is receiving.
Well, that involves, which we'll come to, that involves my lady's suggestion, which is you simply slice through the 14%. We know that what they can't do, because everyone's agreed that under Section 3 they can't reinvent the size criteria, they can't add words, because that would be judicial legislation and not judicial interpretation. So you've got to find a solution that can work under the particular scheme. There isn't a standard answer in all of these cases, and I respectfully agree with my lady that sometimes it will be jolly difficult to work out whether you can do it or whether you can't do it. But in those cases where you can't, you have exactly the dilemmas that are being put to me. And the question is whether you can do it here. Is there some easy way in which you can say, as the FTT, right, well, I know that that doesn't work because it's been held to be incompatible. Now, what money am I actually going to award?
But it's simply disapplying a reduction, isn't it?
Yes.
Well, my lady says that, and I'm going to come to that. I respectfully submit it's not that simple. And it's not that simple because if you disapply the 14%, say, you create a host of problems which I will come to. And you create, for example, and to take but one of them, a disparity between the position in relation to social housing, which has the 14% as part of the mechanism, and the position in relation to private rented accommodation, where because the way in which the regulations are structured is different, that percentage reduction does not operate, simply because of the way it's set up. It's set up so you get a percentage of the private rental for 1 bedroom or for 2 bedroom, and then you just have the size criteria. So what do you do with that situation? You can't scythe through the 14% there.
Well, you might say that the public authority was not then acting unlawfully in applying the legislation because there was no alternative for it. But to
Well, my lady, I know that's why you raised that, and I'm going to continue, if I may, to resist the temptation to go there. But there are the two ways of doing it. You can either do that and you stretch the meaning, and that may have unfortunate consequences in other areas, which is why I'm not succumbing to the temptation, or you have to confront and expose yourself to the sort of questions that you've been putting to me about how can it be right because it's unlawful for the public authority to do that. But either way, I'm so sorry.
No, carry on.
No.
I think that your answer was, in part, make a declaration.
Make a declaration.
But under what? You referred to Section 4, but Section 4 deals with, in 4.1, a provision of primary legislation.
No,
and in
4.3,
it's...
you can't make a Section 4 declaration.
No.
So that's about primary legislation. But the courts have made declarations. The T case springs to mind again. Yeah. They have made declarations in relation to secondary legislation, and they've done so in circumstances and for precisely the constitutional reasons I've identified. And you'll recall in T, it came back to me with a shorter German, you'll recall that in T, there'd been a drama in the Court of Appeal on the ultra vires set of issues, because the Court of Appeal had been thinking very much along those ultra vires lines and had said, well, this scheme for disclosing convictions and cautions and all of that is incompatible, and therefore it's ultra vires, therefore the whole thing goes. Well, the consequence of that was there was then, unsurprisingly, merry mayhem, because the scheme had fallen, and it was a pretty essential scheme. And not merely had the scheme fallen and it was a pretty essential scheme, but that would be grotesquely to over-remedy. And that is not what the Human Rights Act is about. So I'm sorry,
I think I was thinking about the structure of the Human Rights Act, actually, that the fact that there is nothing in Section 4 about making a declaration in these circumstances, and there's nothing in Section 6 about
But you have a discretion in Section 8. And I think it was a Section 8 discretion that was relied upon in the T case when the court considered remedy. What you can't do, of course, and my lady is entirely right, is make a Section 4 declaration, but the significance of the Section 4 declaration, which only applies to primary, inter alia, is that it allows you to do things by remedial order under Section 10.
Yeah.
So it's a very specialist beast. Non sequitur, that because it isn't mentioned, you can't make a declaration in relation to secondary. You can. The court has done it in T, for example. And they do it in T because they don't want to create merry mayhem, because that would be over-remedying, and because it was for Parliament in that context properly to consider how all of that scheme should be reconstructed to conform to the difficulties there under 8 that the court had identified. I got a bit out of order, I'm afraid.
It's quite counterintuitive, at least to me, to read sections 6.1 and 6.2 within the general context of provisions which provide a solution to the problem of incompatibility of primary legislation, as saying that in relation to secondary legislation, the very important principle in section 6.1 must be operated once the court has identified some incompatible bit of the statutory code as requiring authorities to continue blindly applying the code, acting unlawfully, actually requiring them to do so, sure in the knowledge that all the victims are going to be able to trot down to the county court and get automatic awards for damages. It just sounds like a very strange scheme for Parliament to have thought up.
Well, my lord, the alternative is that in the case of, my lord makes a general point, and the alternative in the case of real complication, those examples that my lady was talking about, where it would be very, very, very difficult for the court to fashion a solution, take the T-type example, the alternative is you could never do that. What was going to happen until Parliament, in the T context, what was going to happen until Parliament rejigged the scheme, which isn't necessarily going to take some time? Did that mean that in the meantime, people could not operate the scheme as it had been? Answer, no. They continue to operate under the old legislative scheme until it was changed, and the court has various ways of controlling that parliamentary timetable, CGC, not directly, but people bring claims and the court then considers it and makes further declarations and so on. But my Lord says it's a strange way of doing it, but we are in territory, I submit, where you've got two strangenesses. One of them is that, and the other one is that, because it's a general point, the other one is that it's always open to the FTT to redesign any scheme, however complicated, however appropriate it would be for Parliament to make those choices. That's ultimately the difficulty. That's the dilemma, and it's a dilemma which is thrown up by my lady's question, because we're on the issue: can you make the Human Rights Act work to avoid
Yes,
that?
but
And if so, how?
You're talking about constitutional boundaries. There is the constitutional boundary which my Lord Reid has referred to, namely that the courts cannot be expected to act unlawfully, and that's absolutely part of our constitution. But could you not also say that coupled with that, there is a boundary in that courts do not rewrite legislation, so that you have to take both points together, that the courts can disapply incompatible subordinate legislation, but only within the remit of the judicial function?
My lady, I think one could say that. I'm not sure it would entirely avoid the unlawfulness problem which has been raised, but it would go part of the way there. And the question which it then would throw up is, by reference to what yardstick do you decide how the court should make that choice? Are we within disapplication territory, or are we within other impermissible territory?
Yes.
And if we can get to that place, then I'm happy, as it were.
But it would be a matter of argument and
It would be
submission.
a matter of argument and submission
on
in
the
the
constitutional
individual case.
position.
And it would be determined by yardsticks which are deeply familiar, because they run through the HRA. They
Oh,
are.
yes.
Is it more appropriate for the courts to do this? Can they do that by simply slicing out the one-line jurisdictional provision that is discriminatory, or does this involve a more fundamental redesign of the scheme?
But you're putting to us a complete no-go area.
I'm sorry. ma'am.
Putting to the court a complete no-go area, whereas it may be more subtle than that.
Well, my lady, it may, but the subtlety is, at least on our argument, to be found in Section 8.
Yes, I understand. Yeah.
And really, it's a question of how one gets there. But the dilemma is the same. The dilemma, of course, is that the Human Rights Act has set things up so that public authorities can't act incompatibly with human rights. But they've also done so with, the subtlety of Section 4 declarations. Well, they have a specific and specified consequence.
Yes.
Much more difficult and much more fuzzy in relation to secondary legislation. But you've still got the constitutional boundaries. That's where I was getting to as my second point under this
Absolutely.
first submission, as it were.
If you go back to the indicia in the Act, Section 3, which I know you're seeking to stay away from, Section 3(2)(c) suggests that if you give effect to legislation in a way that's compatible with convention rights, that does not affect the validity of incompatible subordinate legislation unless, and the unless part doesn't apply, which is an indicator that there is some space here.
For that sort of constitutional thinking to work. Yes.
Well, you probably better get on with your second submission.
That. I bet it's been helpful, because at least it's close to the nub of it anyway.
Yeah.
The second was going to be, and I've probably covered it so I can take it quickly, the second was going to be, you'll remember that I said there were two limitations on the Section 8(1) within its powers bit. No power beyond its existing powers. That applies particularly to constrain what the FTT can do. But secondly, the powers under Section 8, and implicit within that phrase, within its powers, do respect and must respect that basic constitutional division and allocation of responsibility as between the courts and Parliament or the legislator. And if you want a series of statements, I keep referring to the T case, but that idea, particularly in the judgments of Lord Wilson and Lord Reid, who conducted an intensive analysis of this whole suite of provisions in that case, but the theme that runs through them is the respect that runs through the whole of the HRA for that constitutional division. See Para 65, page 1110, Lord Wilson, and 149 in particular, 1130 in Lord Reed's judgment. And it is the central theme that runs through the HRA. You find it in section 3 and 4. You've got a whole raft of case law which you will need no reminding of, Gaydan and all of that, on when it's appropriate for courts to be able to interpret under 3 and when it's not. That's about this distinction. That's exactly about that. And the critical constitutional principle in play, is that it is for the legislature to design and redesign legislation. And there is a proper dividing line in terms of responsibilities between the legislature and the courts or the tribunals.
Because, of course, Reed didn't raise the problem that we have in this case because the legislation in issue there wasn't being applied by public authorities. It was it operated on private individuals who sought employment from employers, and they were required by the legislation to disclose.
They were, my lord, you're right, almost adventitiously, as it were, because they had to make the application, and that was the way the legislation was structured. But it's not very difficult to recast T as a mandatory scheme that requires the public authorities to get, if you see what I mean. So my lord is entirely right, but whether that subtlety really works in our context, maybe a nicer question, perhaps. But the context we have here is, of course, discrimination and a potential range of options for how you would go about sorting discrimination generally and here. And there was, as you've seen, of course, controversy even about the nature of the legislation, as we see from the various different tribunal decisions and how ultimately the Supreme Court decided that. But there are then a wide range of possible solutions legislatively in the context of sorting that discrimination as part of the overall scheme of social security benefit with finite money. And you've already seen, or you've seen in our pleadings, the nuanced solution in fact adopted in the revised legislation, conveniently, I hope, pulled together in Appendix 1 to our case with the bits underlined so you can see it. But the submission of principle is that where you've got a variety of choices as to how the incompatibility could be dealt with, they are properly decisions for the legislature, because they are legislative in nature. And the courts and tribunals not merely should not do so, but are not properly placed to do so. If, for the sake of argument, you could design or redesign in a variety of ways, how would the court assert jurisdiction, to start off with, to say the new scheme should be X rather than Y or Z? And it follows, if that is right, and that engages the legislative concern, that neither can the court or the tribunal say, well, we're now going to make an award or declare an entitlement which is premised on the design being X or Y or Z. That's just as objectionable because it requires as a precondition to making the award as a point of entitlement, you to have redesigned the scheme. And that is a constitutional principle, and it's a constitutional principle that has been consistently recognised by the courts. I'm not going to go through all of the cases, but, and I'm sure I'll be told that I've misread them, but we've cited in our case, as you've seen, the SG case. If I can just invite you to take up our case, I can probably take it swiftly from there without turning them up. I'll give you the references as we go. So it's paragraph 41 of our case, page 134 in the electronic numbering, and we've cited my lady the President in SG at 41.1. Deciding with Lord Kerr also agreeing on that front that because there were several different ways, I'm taking the wording from 231 at the top of page 135, because there were several different ways in which that incompatibility might be cured, most notably perhaps, etc., drop 4 or 5 lines down, it has not been shown that taking the child-related benefits out of the cap as it applies to lone parents would do so, and so on, then the remedy is declaration. leaving it open to Parliament to recast. Query, in relation to that context, what happens in the meantime until Parliament is recast, but that's the declaration respecting, in terms of that relief, the constitutional boundaries I've identified. We have My Lady the President again, 41.2 of the case in Humphreys, to similar effect. We have the Carmichael case, which you've already seen, and My Lady drew attention to the nature of the declaratory relief only that the court had ordered in that case. And just to bring you bang up to date on this raft of cases from the Supreme Court in the context of social security, can I just invite you to look briefly at DA, the second benefit cap judgment, Authorities Bundle 1, tab 13, page 642, is where the judgment starts in the electronic, and the page I want on the electronic is 674. So the premise, this is obiter strictly, but it matters not, the premise is that there's no convention-related discrimination found by the court in that case, but paragraph 90 proceeds on the premise that there had been. If there had been, what would have happened? Can I just invite you to remind yourselves of para 90? So you've got the same sort of thinking there, and there's concern even about making a declaration in that context, or there would have been concern even about making a declaration because of that constitutional divide. But the logic of the position is that even though the Supreme Court in these cases has restricted itself to declaration, and would in that case even have been concerned about making a declaration, but has restricted themselves to declaration, that it is, and they've done so because there are a variety of ways in which Parliament can sort, and it's appropriate for Parliament to do that. The logic of these cases is we don't need to worry about any of that, even though the Supreme Court has been constitutionally timid, as no doubt the appellants would characterise it. It's nevertheless appropriate for the FTT or local authorities themselves to redesign the scheme for the purpose of deciding what the premise should be for the new award of money or entitlement that they're going to make. And my submission is that it isn't part of the FTT's powers to go beyond what even the Supreme Court are concerned about doing, and themselves to redesign the scheme as the essential premise for creating the new monetary entitlement. So here, to come from the position of principle to the position here, there is a need, or there was a need, for Parliament to consider making a variety of decisions in order to arrive at the solution that they eventually arrived at. And you know the decision they eventually arrived at because you have it summarised at Appendix 1 of our case. Most conveniently there set out. 149 and the electronic numbering, if you want to have that to hand to see what they actually did. And you see that what they've done is to alter the size criteria by adding ZA and ZB to para 5, and they've then defined what member of a couple who cannot share a bedroom means over the page, top third, and they've done so in their way by identifying various rates at which allowance is paid under various other bits of legislation. The detail may not matter, but you see that there's a whole variety of nuanced judgments being made within A of the definition. Those are the qualifying criteria, in effect. And then they introduce B. So that's what they ultimately do. But my submission is that in nature, those are decisions, those sorts of decisions. Should there be a new category? How should it work? By reference to what rates, the higher rate, the middle rate, any other rate, Can we afford to do this for all the comparator groups that have now been held to be discriminated against? Levelling up, levelling down, all of those are paradigmatically legislative decisions. And I characterise them in that way, applying, but by analogy, let's be very clear, the sort of thinking that one sees most clearly when considering that dichotomy between Section 3 and Section 4 of the HRA, the Gaydon and Mendoza line.
And presumably when these regulations were put before Parliament, there was an explanatory document explaining what choices had to be made to the social...
I'm sure there would have been. Yeah. And the decisions were to be made in the light of the Carmichael findings. So if one wants to break them down, if one wants to list some of them, you've got to decide that you're not going to level down, assuming that one could perhaps do that. You've got to decide that if you're going to, perhaps more realistically, level up, so as to include the additional category, you can afford to do so, just simply by introducing the other category, and you've then got to decide whether you need some intermediate position, which may well have an impact on the nature of the qualifying criteria as I described them in that definitional section. And then what you've got to do is to add another category to the size criteria. Here, member of an adult couple who cannot share a bedroom. You actually are adding, you're putting the words in. Those are the words that effectively, those are the words that the FTT couldn't put in under Section 3. And you need to then define what you mean by that. If you're going to add a new category to do the Gorry counterpart, as it were, what do you mean by that? And that's a money thing and a definitional thing, because you've got various higher rate, middle rate, and so on in the definitional section. But who fits into the category? What does it mean? It doesn't need to be any person who needs an additional room. That would be over-remedying, because we know that the Supreme Court drew the distinction that it did between the MA cases and the Carmichael-type cases. And so you tailor it to the Gorry counterparts, if that's what you're doing and that's what you want to do as Parliament, and you make choices accordingly, all of which have social and financial implications and need to be thought about in the context of an overall scheme, which, as you've seen, is of some complexity, relating to social security entitlement. And it is to be noted, when considering those choices and the subtleties that they bring, and whether they're truly legislative or for the FTT or even perhaps the local authority to start making, none of those, in the end, correspond to exactly or precisely the sort of solution that either the FTT thought it could do, wrongly, under Section 3, or that the upper tribunal thought it was going to do when it disapplied Section 4, the 14% figure. And as I say, the alternative is in some way that the legislation is rewritten and the scheme is simply redesigned in advance of parliamentary consideration by the FTT. And that has the twin problems of the structural redesign, if that's what they're going to do, leading to all of those sorts of issues. How on earth can the FTT start making those sorts of decisions? This isn't just a constitutional propriety thing. How institutionally are they competent to do that? How can they make the decisions as to whether or not, for example, the attendance allowance should be at the higher rate or at the middle rate or some other rate? How are they going to decide whether they do or they don't want to just introduce the category and create exact equivalence? How, if they're going to create exact equivalence, do they decide whether the money should be effectively the same or they can't afford it, so it should be in the middle? It's just impossible to see, we respectfully submit, how one could go about doing that, either constitutionally or institutionally. And it also leads to the problem that we've described in our case as the patchwork problem, which is all of that, all of those are problems which exist even if you could design a common and uniform set of answers. But it's far from clear that any such assumption could be made. If there are, for the sake of argument, a variety of different ways in which a scheme could be rendered compatible following a finding by a court of incompatibility, if that is the premise, would it be open to a FTT in one jurisdiction to say, well, I think it ought to be done in that way, and for an FTT in another jurisdiction to say, no, I don't agree. I think you ought to be doing it that way. That still achieves compatibility, but you need to do it the other way. So would you have a series of different possibilities, a series of different redesigns as the fundamental precondition to the awarding of new entitlement? And we respectfully submit that's very, very difficult. That's the first submission. I should push on a bit, I'm afraid, but that's the first constitutional submission. The second one is that the FTT or upper tribunal solution based on entitlement, we submit, does cut across the HRA's provision or provisions governing damages. And it does so because some form of, quote, entitlement, close quote, award raises precisely the issues I've just dealt with. And that's because it would necessarily involve, as a precondition, a redesign of the statutory scheme to turn it into some form of, quote, entitlement award, even though they couldn't get there using Section 3. But so far as the damages are concerned, the power to award damages is dealt with in the Human Rights Act, if you go back to that in Bundle 1, in Sections 8.2 and 8.3. There is a power to award damages, but it is a power which is restricted to a court which has the power to award damages. So this one does not apply to tribunals. And of course, the power to award damages, as you know, under 8.3, arises if it's necessary to do so to afford just satisfaction. And you know that that brings in the Strasbourg case law, and the first port of call that Strasbourg thinks about is declaring the incompatibility enough, or should there be some financial award, and if there should be a financial award, it's conditioned by Anu Free-Java and all that line of cases. But the points to note in relation to those provisions taken together are twofold. Firstly, the High Court or County Court could do so, but the FTT cannot, or at least ordinarily cannot, and I put it that way because, as ever, there's a subtlety, and the subtlety is that it could do if it was exercising, the upper tribunal could do if it was exercising judicial review powers following a transfer from the High Court. But subject to that, it's a court power, not a tribunal power. So the tribunal cannot award damages. And secondly, we know that the principled limitations imposed under the HRA are, in effect, to drag the award of any such damages and the consideration of whether they should be awarded into the jurisprudence that Strasbourg has produced, if that makes sense. So you look to see the Strasbourg case law, and we know what Strasbourg does. They consider whether a declaration is enough first up, and if not, they apply effectively restitutio in integrum. That's the basic and guiding principle. Has loss, in fact, been suffered as a result? Was any such loss caused by incompatibility? If so, what's the appropriate quantum applying the Strasbourg approach? And the difficulty that that creates is, first of all, jurisdictional. And it's jurisdictional when one considers the position of the FTT, because their only function is to determine entitlement under the legislative scheme when it comes to money. They do not and cannot award damages. And so they can't do that which the HRA remedial scheme envisages, which is to compensate for loss in appropriate cases by damages. There isn't some form of implicit power in Section 6.1 that gets around that difficulty. And so far as other problems are concerned, the additional problem, particular problem, with other attempts to get a monetary remedy are that you are casting what is in effect an award of money under the guise of entitlement in circumstances in which no one contends that the FTT could take into account DHPs in fact awarded. And so the consequence in the FTT's hands is or may well be double recovery, and it's very, very difficult to see how that could be squared with the clear intention of the HRA, which makes specific provision for damages and consequences in terms of consequences flowing from unlawful or incompatible acts, and under which the governing principle is restitutio in integrum. And that is a problem. It is unsatisfactory, we submit, simply to assert in answer to that that the local authority may or may not have power to seek recovery of the DHPs. The FTT can't take them into account, we agree, and it's their remedial power which is in issue. I say can't take them into account unless you're right at the back end of the analysis and all the principal rules in the HRA have been thrown up in the air and it's all just a matter of discretion to do what is just and so on. You just don't have to worry about any of these restrictions, and you can call what the FTT does something which you can characterise it as not being damages. So they're giving an entitlement, they're making an award, but it can't be damages. So you've got to call it something else. And if at that stage it's all up in the air, well then all bets are off because all rules have gone. But subject to that, they can't take it into account. And in any event, for the reasons we deal with under issue 2 in particular, at the end of our case, it's wholly unrealistic to suppose that this works. Unrealistic not least because no doubt in these sort of circumstances the money would already have been spent by recipients. There's no power in the Secretary of State to force local authorities to go down this route and no real incentive on them to do so. And it is not possible, contrary to the final paragraph in the upper tribunal's judgment in our case, it is not possible to set off DHPs against housing benefit for government to do that. That's just simply not possible for the reasons we give in paragraph 68.3 of our case.
Can you help as to which provision it is that governs the appeal to the FTT? I've looked at page 447.
Yes, I'm sorry, I did ask that question yesterday and someone gave me a little list of provisions. Is it Reg 89?
It's paragraph 6.1 of Schedule 7
Yes, sorry.
to the Child Support, Pensions and Social Security Act 2000.
Is that 447?
MS 447.
I'm very grateful.
447's missing 9 from it. Well, it is in my copy anyway.
Do you want another page?
Is that right?
Oh yes, that's true.
Because 9, at least in one version of it, says that in deciding an appeal under the paragraph, the FTT shall not take into account any circumstances not obtaining at the time when the decision appealed against was made. And my thinking with regard to issue 2 on that basis is, at the time the decision is made, the discretionary housing payments haven't been made because they're made to top up, having made the decision that there isn't going to be full housing benefit. And the FTT is only dealing with it at that point. So no question arises at that point about discretionary housing payments, if that provision is right. But it's not here in the bundle.
Because you haven't got the page number, or because...
Well, I just haven't got anything after 8. I looked it up myself.
Oh, I see. I'm so sorry. Yes, well, you're right, and I haven't either, I'm afraid.
No, but there is a 9.
There is a
At
9.
least on Westlaw, there's a 9.
There's a 9 which appears to contain
Which says
something relevant.
that.
We better get you that.
Maybe we had.
Yeah, but you're Madam, you'll know that the...
Mr. Drabble is looking as if he may know the answer.
Well, I'm pretty sure that is the answer. I hadn't picked up it wasn't here. We've dealt with it by taking the court to RIB 2/04, which is a complicated way of describing an upper tribunal decision,
Yes.
at MS 1078, paragraphs 19 to 25.
1078.
It's paragraph 5 of our printed case gives the reference at MS 103. And the basic idea is that the tribunal steps into the shoes of the original decision maker.
Yeah. But it would be good to see it in the actual...
Yes, we need 9. We need 9.
And what I couldn't find in that either is what the power is of the FTT on hearing this, because it doesn't seem to be spelled out in that provision.
That's the IB decision again.
That is the IB decision.
Right.
It's the best I could get. I mean, I was trying to.
15 to 18.
It's a complete rehearing on the principles spelled out in our IB, whatever
Okay.
it is.
Yeah.
But the fundamental law used to look at the situation as it evolved over time. You don't anymore. You look at it as a... And so the question about the status of the initial decision is accordingly quite important when you're looking at the jurisdiction of the FTT.
My lady, I don't think there's a great deal between my learned friend and I on the basic jurisdictional reach of the tribunal. You'll appreciate we just draw different consequences from it. My learned friend says, so you can ignore it for this purpose. And I say, the difficulty, of course, that it creates is that if you're going to invent this sort of new entitlement, you may well have to confront the difficulty, which is that that would lead, precisely because of that, to double recovery. Unless, of course, and this is the answer that the upper tribunal gave in the passage my learned friend took you to this morning, unless you can say, well, actually there's a power in the local authorities, or maybe a power in the local authorities, to claw it back. But from the perspective of the FTT, we do not believe that they can take these into account for the purpose of balancing it up. And that's why I say, in order to get to that place, and this may have been Lord Justice Legate's reasoning, which is our alternative case under issue 2, you get to a place where all rules have gone, all the cards are in the air, and you just say, well, it's a general matter of discretion under the HRA, so they can drag it in that way. But there is a fundamental jurisdictional difficulty, which we say feeds back into the constitutional impropriety, as it were, and the difficulties of the FTT trying to do this sort of exercise. Because if you were truly going to do this sort of exercise, you would be thinking damages in a nutshell. And you'd be thinking damages because you wouldn't actually be doing entitlement under the existing legislative scheme. By definition, they're trying to rewrite it in some way. And so you're doing something else, something between entitlement and damages, whatever that may be.
But we're looking at all of this through the medium of money, money regulation. It may not be a money regulation and therefore not so susceptible to
It may not be.
damages. For example, it might be that you can't adopt if you're one of an unmarried couple.
My lady, it may
But
not.
still, the court has to perpetuate that unlawfulness by continuing to enforce that.
Well, it would depend. I mean, I don't make these as general propositions. It would depend on the nature of the scheme. It would depend on how readily or independently, as it were, one could address the particular provision. But you apply, is my submission, essentially the principled approach that's been well developed on that distinction between Section 3 and Section 4, and you ask the question, can the court effectively cure the compatibility in a nice, straightforward, sensible, easy way which does not trespass into the court or a fortiori tribunal or even more a fortiori public authority, redesigning a complex scheme by inventing new size criteria or whatever it may be. That doesn't admit, therefore, of a uniform answer. The submission is you apply that principled approach and answer the question. That's why I described the secondary legislative position under the HRA as much more fuzzy and muddly, because it is. It is jolly difficult because you get exactly these sorts of dilemmas. But in our context, to come back to us, the money thing is important because that's ultimately why people are thinking about, well, what happens if you can't just get rid of the 14%, which I'll come to, or do some other thing which will get them effectively the same amount of money as those comparator people. That's the game that is afoot in our particular context.
I wonder, is a possible way of approaching this to say that Section 6 of the Human Rights Act, subsection 1, in saying that it's unlawful for a public authority to act in a way which is incompatible with the convention right, has to be applied taking account of the limits of the powers of the public authority in question. And for example, whether you're dealing with a court or with a legislature or with the executive, what it can lawfully do or not do in terms of Section 6.1 may depend on the constitutional limits of its powers.
Well, yes, and that's what we're back, I think, to that basic question. Do you do it by saying, no, I'm afraid we have to acknowledge unlawfulness, but nevertheless, you then move to see what you can do about that, and what you can do about that is Section 8, with its own banging of that drum by saying within the powers of, i.e. not beyond, or you say, no, you can approach Section 6.1 in this way. You would have to confront the oddity if you did it in the way my Lord has just suggested, which is that if you accept that and that concession of interpretation in relation to 6.2a, I think it's the point that my Lord Briggs was putting to me, that you have this oddity of 6.2 having made very specific provision for primary legislation, no equivalent in relation to secondary, but you're still doing something else. But it may be that just that subtlety is inherent.
Well, I was thinking, I mean, given that act includes failure to act,
Yes.
there are all sorts of things that courts don't do.
Right.
And
Yes, that's
and which, you know, if there are also things that somebody who wanted their rights, convention rights vindicated, might want a court to do, which it can't properly do. And the answer to that may be that you read Section 6 within the context of our Constitution, and as you say, that would then, it wouldn't give you a bright line rule, but it would mean you have to have regard to the particular problem that the convention right gives rise to.
And if you do it that way, then the other indications that exist, including the indications that my lady drew attention to in Section 3, start to play, and you get the same thought in the point my lady was putting to me, and you get the same thought in within its powers in Section 8.1, and you get a similar thought elsewhere, but more directly with more prescriptive rules in 6.2 A and B in relation to primary. The question is always, when I was trying to prepare this, the question always was, do you just flip from a position which is specifically regulated primary, things being compelled by primary, to a conclusion that the opposite must automatically be true in relation to secondary? And I think the base submission that I'm really making is that that's far too simple. And actually what happens is you don't flip to the exact opposite. You just flip to considering the thing on a much more discretionary basis, applying the constitutional themes that run through this Act.
Just swiftly, there is a VAT case in the House of Lords in which the European Court had said the domestic court should do X, Y, and Z. When it came to the House, they decided that it was not consistent with the constitutional function, so they refused to comply with EU law in that regard.
Yes.
I think it was Condé Nast, but it's analogous.
It is analogous. I think the only note of caution perhaps to urge in relation to EU law is that, as we know, under our Constitution, it has a far more punchy resonance.
That's why I thought it was an example.
Than the HRA, but even there,
the constitutional boundary was written in.
Yeah. And my ladies, my lord, the end to this second submission about damages is that under the scheme of the Human Rights Act, Parliament has made the choices that it's made about where you have to go to get damages. But the critical point for present purposes is if the FTT cannot redesign the scheme and create some weird hybrid between damages and entitlement, that does not mean necessarily that the individual is left without a remedy under the Act. Of course, it would do if you decided it was lawful, applying the Section 6 thing, but if it's unlawful, they can claim damages for a breach of the Human Rights Act, and that is the provision that Parliament has made. Now, my learned friend Mr. Chamberlain said in a swift peroration at the end of his submissions this morning, that's all jolly difficult, very impractical, might have to do legal aid, might have to do all these other things. Well, so be it, is, I'm afraid, my rather ruthless answer to that. This is a scheme that the Human Rights Act has set up, and it provides, we're dealing with what this Act means, what it's designed to do, where the balances are within it. And my submission is that the bull point in relation to damages, there they are, in the Act itself. The third submission then, if I can take the last few very speedily, the third submission is that disapplication illustrates rather than obviates the difficulties that I've identified in the first two submissions. And it is not, I respectfully submit, a remedial solution. It's not open to the FTT to disapply, whatever that may mean, I'll come back to that, because it's no more acceptable to do so for the purpose of creating a money award. It is no more acceptable than introducing wording and purporting to use Section 3, which everyone agrees cannot be done. It is precisely to the same effect by either route and just as constitutionally objectionable. You are creating an entitlement or a non-reduction in circumstances where it is plain that Parliament intended there to be none. Now, they were wrong about that, and that was discriminatory, and something's got to be done about that. But, and as I say, and as I've said, I'll just make the point and leave it there, in most, if not all, discrimination cases, there will be different ways of resolving it. Level up, level down, introduce new conditions, take from another part of the scheme to conform to the spending envelopes and the finite money.
Could I just go, I'm not sure where it goes, but you're saying there is a remedy, it's a claim for damages, so it's a Section 7(1)A claim with the remedy being damages. That would be a claim made to a court with the power to award damages. Against whom would that claim be made?
Well, they could make it either against the perpetrator of the, they could make it either against, I suppose, either against the Secretary of State or against the local authority, or both.
Well, the local authority on your case has no choice but to apply the regulations in their current form. That's your case, that they have no choice, and the FTT also has no choice. So is it seriously to be suggested that the damages claim could be against the local authority?
Well, my lady, it could be against them or it could be against the Secretary of State. There are only two possible targets. And the local authority may or may not be able to say, well, we're entitled to rely on the legislation.
Well, it's an interesting situation, isn't it? So is it any less unlawful for the local authority to pay damages based on what's been lost by way of a money claim for benefit than it would be to pay up the money for the money claim?
It would be less unlawful, and it would be less unlawful because the human rights precisely permits a damages claim in these circumstances, and it does not permit, on my submission, it does not permit the redesign of the legislation and the creation of some new entitlement, because that is for Parliament.
And how would the court decide what the counterfactual is? You know, how do you measure the loss?
Well, I suppose the answer to that is they would say, well, there may be, I see the force of that. There may be difficulties with that if you're trying to work out what Parliament might or might not.
Well, exactly.
And they may be able to say, well, look what they have done, and that's enough.
Yeah, well, I'm just wondering if your argument doesn't rule out a damages claim just as much as it rules out a.
I'm not sure it does necessarily, because you know what Strasbourg do. They don't necessarily demand counterfactuals and chase the loss through as one would do in an ordinary commercial or other damages case. There is capacity to award broader general damages under that jurisdiction, and I'm sure there are a whole series of arguments that would have to be gone through.
So it wouldn't really be a pecuniary loss. It wouldn't really be an award for pecuniary loss. It would be some sort of non-pecuniary award for the outrage of being discriminated against.
Well, it might be, but you end up in exactly the same, if not more difficult situations if you're getting the tribunal to do that exercise. If the tribunal's not doing that exercise, what's it doing? Is it considering loss under the HRA? It's certainly not considering entitlement under the legislative regime because it hasn't been amended yet. So what's it doing? And the difficulty, of course, jurisdictionally that it has is that it can't take into account the DHPs at all, assuming we get to that place.
I'm sorry to detain you on what's, I think, probably a very silly question, but what is Section 10, subsection 4 doing?
Of the HRA?
Yeah. This is contemplating a situation in which the provision in question is in subordinate legislation and has been quashed.
Yeah.
Now, who's quashed it?
Court have quashed it.
Right. Which court? Just not a tribunal or
Not
an
a
upper
tribunal.
tribunal or a court of appeal?
They haven't
or
got powers to do that. It would be the
It's a question of power of that individual institution.
It is. And
So it can be done,
It can
but
be
not
done.
by those courts.
there's no question but that it can be done. You can strike it through and so on. I mean, there may be extraordinarily good reasons why you wouldn't do that here, back to the Varies
Yeah.
thinking, because you would
Of course, the upper tribunal can do that in judicial review proceedings.
They can, but then they're effectively acting qua High Court.
That's true.
But you could bring a parallel judicial review proceeding
You could.
and
You can
thereby
include-
get to
and-
this
and
very position.
You can, and you can include damages claims within a JR claim and all
Yeah.
the rest of it. So there are lots of things you can do. But I'm not taking a position that under this jurisdiction, it isn't open to the courts to quash secondary legislation. But in doing that, they would exercise the remedial discretion for this purpose, which Section 8 confers upon them. This is the consequence of how you put it right when they've done that. But for the purpose of the quashing power, you find that in Section 8. And they would exercise that discretion by having regard to all the things that would play on whether that was a good idea or a bad idea or an indifferent idea, back to T in the Court of Appeal. If the consequence, because you couldn't, for example, easily knock it out as a 14% thing and get rid of it, if the consequence was you'd have to declare the whole thing unlawful because it didn't include this particular category, and because, for the sake of argument, to go back to Lord Reed's example earlier of this being a systemic or structural problem, because it's all people in the group who've got to be covered or not, subject to definitional nuances, then if the consequence of that is you can't actually redesign it simply or do it simply in that way, and you're just thinking about the exercise of the enabling provision power to make the regulations, or you're thinking about quashing it more generally, because you can't sever, back to Mr. Squires' point, then the question that the court would have to consider is what would be the consequence if I did that? And if the answer is, well, it would eviscerate the regulations, then you haven't got a system for the award of housing benefit or for doing all these things. So that's highly unlikely in any real world scenario. That's highly unlikely to be a remedy that a court would grant. And all of the case law in this court has constantly banged the drum for saying you need to tailor your remedy to and only to the incompatibility found, and you don't over-remedy. That's no part of the function of the court under the HRA. And so it does come down to whether you can find a nice, simple, straightforward, easy solution, knock out the 14% and move on. Because if you can't do that and you're left with the more nuclear options, no court is ever going to do that, because it would create unintended consequences and it would over-remedy. Unintended, I would add, and unfortunate consequences, and it would over-remedy. Can I come directly to the various alternatives for how we arrive at the simple solution? No one is suggesting, to go back to my Appendix 1, no one is suggesting you delete 5BA. That's the Gorey equivalent. That would be levelling down. And unsurprisingly, no one is contending that, but it's, I suppose, a theoretical option. Then you come to sever or disapply the 14% in 3A, which appears to be the candidate that sounded most attractive. Well, you need to be clear what one's talking about there. If you sever that entirely, if that's what you're talking about, it's impossible to see how that would work. It isn't the problem provision. 14% is not the problem provision. It's an integral part of the scheme as the consequence of the application of the size criteria in this formulation. So if you sever it, you're undermining and fundamentally altering the scheme, and you're doing so in a way that is not required by the discrimination found. It doesn't, in any event, if you did that, address the discrimination found. The size criteria for all those in the comparator groups was the problem, not the percentage. And it doesn't work for the private sector anyway, for the reasons we've given in our case at paragraph 55.6 and that I described earlier on. And if you want the equivalent regulation in the private context, I'm not going to go to it now because I haven't got time, but it's Authorities Bundle 1, Tab 2, page 419, and it's Regulation 13 sub D. And just to summarise it very, very briefly, for when you get there, what you do under that private sector bit of this legislative scheme is you calculate the market rent for the category of home you have, 1, 2 or 3 bedroom, and then you simply apply the size criteria to that. And so that's how it works. But the key point is you don't have 14% and 25% as the legislative mechanism. You have a differently structured thing. So if 14% is the problem, what do they do when the first person comes along and they say, well, hang on a second, we'd like the 14% applied, and they look at the regulation and it isn't there. And what that illustrates is the fundamental truth about all of this, which is that what you're actually focusing on is the size criteria. And what the size criteria, what needs to happen to the size criteria is precisely what did happen in the end, which does not involve an excision from the scheme. It involves an addition to the scheme. You've got to redesign to address and only address the GORI counterpart. You've got to redesign the scheme by adding the new categories that have been done. And once you've added them, you've got to define them. But it's an addition thing. It isn't realistically something that can be sorted by severing. There are other problems with simply severing the 14%. And that is that they include not merely that you then create this complete disparity with the private sector scheme, but you then don't have a scheme which looks at and only looks at rectifying, in the way Parliament thought appropriate, the discrimination found. You don't have, for example, by doing that, any of the preconditions that are included in the definition on page 148 of Appendix 1 in our case. Higher rate, lower or middle rate, higher rate, and so on. All those subtleties of distinction, you don't have any of them. And you have the problem that we've set out in our case at 55.5, which is, well, what if you get rid of the 14%, what if you're under-occupying by 2 bedrooms? We know that it went 14%, 25%, but what if you're under-occupying by 2? What then happens? And all of these are just ways of saying the same thing, which is that in order to sort the problem, you have to add and you have to redesign. You can't just take a nice clean side through it. This isn't something with a jurisdictional precondition that says this social security benefit only applies to a particular protected group, something. You just strike that out and move on, arguably. This involves a redesign, however you put it, and the problem that that creates is illustrative. And it's illustrative because the moment you acknowledge that, you are straight into the territory of the unacceptability, which is common ground, of adding the words in by using Section 3 of the HRA. And we respectfully submit that all of the other various suggestions that have been made across the cases about how you might go about doing this. Take out a couple and then you drop down in the menu, or do something else. I mean, they're all aspects of the same thing. Ultimately, they don't focus on the problem that was created by the finding of discrimination in this court. The only way you can do that is by creating a new category. That requires you to add words and then define. I see the time. The fourth submission was going to be, we've covered it already, you can't create or achieve the jurisdiction or power to do all of this by relying on section 6.1 or 7.2 of the HRA, but I think I've covered that sufficiently. Matheson, or Mathiasen, if that's the right way of pronouncing it.
No, Matheson.
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 As in Jordan Matheson.
Grateful. Well, I'd always thought of it as Matheson, but someone was trying something else this morning. Matheson, we've dealt with in some detail on our case, and we also respectfully adopt the pretty extensive analysis of the majority of the Court of Appeal as to why Matheson is not the answer. In a nutshell, Matheson is not the answer because I know the court's initial reaction may have been, this is all jolly easy constitutionally. I respectfully submit it isn't. And the difficulties and the subtleties and the thinking that has fed into all the parties' attempts to assist the court in this case were simply not considered and ruled upon in the very truncated section of the court's judgment in Matheson. But perhaps more importantly, Matheson was, it appears, an example of a case in which a specific finding was made that this individual case could be dealt with, as it were, as an individual case. It was about evaluation. It didn't create the structural problems, to put it in that way, that we're having to address here. So for all of those reasons, and for the reasons developed in our case and set out in the majority's judgment in the Court of Appeal, we respectfully submit that Matheson is not a complete answer to this appeal, very far from it. I've tried to weave in the answer to issue 2 while making the submissions. You know what I say. I fundamentally agree that the FTT can't get into this, and so you've got a double recovery problem, and that feeds back into issue 1. But if you do get to a place in which it's all HRA up in the air and everyone can do what they want and the rules have gone, then we agree with Lord Justice Leggett on an alternative basis. But it is an alternative basis. Ladies, my lords, I'm sorry I've gone over, so apologies to my learned friends as well, but those are my submissions unless I can assist further.
No, thank you very much indeed, Sir James. Mr. Brown?
Cheers. My ladies, my lords, a limited number of points in reply. First of all, can I deal very shortly with the way I now see the debate we had this morning about a difference based on an approach to the regulation saying the size criteria are ultra vires, and the approach that I have indeed seen in this case, which is based on my section 6.1 analysis. I can see that the size criteria might indeed be ultra vires insofar as they are based on an irrational or stroke incompatible assumption about who can share a bedroom, as was being put to me this morning. What you're looking for as a decision maker or someone applying the scheme are people with a transparent medical need which falsifies the assumption behind the size criteria. It may be because you need a carer, which is not part of the normal assessment unit, or it may be because 2 individuals can't share. So I can see an argument, at the very least, for saying that if you're just looking at the size criteria, a limited attack based on irrationality or incompatibility on the line of the sewage charges case, leaving most of the regulation, most of the application of the size criteria lawful, but holding that they're ultra vires as applied to the limited class, might be a way of looking at it. But as far as I can see, and this I think is what Mr. Chamberlain was saying, the impact on the individual case from the point of view of a decision of Sefton or the FTT is identical. You end up with an award of housing benefit of £X, whichever route you take, because it's not the job of either Sefton initially or the FTT or upper tribunal on appeal to do anything other than decide what size criteria can be applied compatibly with the convention, the individual claimant's convention rights. You get the same answer whether you do it in the way that I've tried to describe it, or you make an assumption, or the FTT delivers an analysis saying that the size criteria as applied to this group are ultra-vires. The FTT, as we've endlessly discussed, can't quash the regulation. It's got to decide the individual case. So you end up in the same place. What was being put to me this morning by members of the court during argument was that there might be a knock-on effect on the second issue. With respect, I don't see that. The position as far as ultra-vires is concerned is if the FTT approached it on the basis that the size criteria were in part ultra-vires, is that it would award £X. It would not, I think Mr. Eady now, Sir James now accepts, would not have the vires to look at the payment of DHPs. Come back to just dot the I's and cross the T's on that in a moment. Because it's not their job. Their job is to fix the maximum amount of housing benefit. So my respectful submission doesn't have a knock-on effect on the second issue. The limits on the exercise of the discretion under Section 8.1 would just mirror those which you had in place in any event when the tribunal is awarding the amount of maximum benefit on a presumption that some part of the size criteria are ultra-vires. You still end up in the same place. So it's too dogmatic in my answer to say that ultra-vires have nothing to do with it. I can fully understand and put my hands up to the fact that there is an analysis on the lines that was being put to me. I just don't see, with my respectful submission, that it makes any difference. The second point, which is hinted at in by my learned friend's statement of case, is the submission that in Carmichael, in the Supreme Court, the judicial review Carmichael, the submission is that there was no finding of a breach of convention rights because of any transparent medical need. The submission tends to limit the finding of breach of convention rights to the different treatment of children and adults in the two different classes. I don't accept that. So I think I said this morning, the starting place is Burnip. I won't take your ladyships and my lords to it, but Burnip is at Authorities Bundle 110, it's MS 572. The critical discrimination that was established in that case was the discrimination between the disabled and the able-bodied on the basis that the accommodation needs of the disabled were not being met, but the accommodation needs of the able-bodied were being met. And the relevant paragraphs in which that can be seen are paragraphs 10 and 11 in the judgment of Sir Maurice Kay, and paragraphs 63 and 64 in the judgment of Mr. Justice Henderson. And of course, so the initial position, before there were any amendments to the scheme at all, you have a straightforward discrimination case based on discrimination against the disabled. You then get modifications, first of all in relation to adults who need carers, then in relation to children who can't share. That produces an illogical hodgepodge, which is what leads to the position in the judgment of Lord Toulson in Carmichael in the Supreme Court. But you can't get away from the fact that had there been no legislative amendment, all the classes in Carmichael, Burnett, Gorrie and so on would have won on the basis of a simple discrimination case alleging discrimination between the disabled and the able-bodied. So I just don't accept that you can in some way pare back the reach of Carmichael or Rutherford, because the deciding factor at the end of the day was that the thing got so far that there was an illogical erosion of the position between children and adults in the two different classes. Third point is I think I now have an answer to what the Secretary of State's case is about the status of the original decision of Sefton, made, as I submitted this morning, before the size criteria came into force and in the shadow of them coming into force, I mean, days before they came into force. On the status, as I understand the submission, is that the decision is unlawful. I think Sir James expressly accepted that, but it must be given effect to, both by Sefton had no choice but to make an unlawful decision, and by the FTT. The FTT has no discretion but to leave in place an unlawful decision. Now, in my submission, that is simply an untenable position. If the court will look at, I think for the first time, an authority in the interveners bundle, which I now, of course, lost. It's the interveners authorities bundle 3, MS 1195, wherein the Attorney General's reference number 2 of 2001, wherein the speech of Lord Nichols, and there is a very forceful passage about the effect of Section 6.1 of the Human Rights Act and unlawful conduct in paragraphs 32 through to 35.
Can you just give the page number?
At MS 1195. It's internal, page 92 of the authority.
Thank you.
And the court will see that, for example, at the end of paragraph 32, just below letter G, Lord Nichols says public authorities cannot lawfully, that is properly, conduct themselves in a way which is incompatible with a convention right. And then 34, the court itself is a public authority for the purpose of these provisions. What if the conduct of which complaint is made is conduct by a court, as where holding a criminal trial would itself be incompatible with a convention right? In other words, what is the effect of these provisions when to try a person for an alleged offence, and if he's found guilty, sentence him for that offence, would itself be unlawful by virtue of the express provisions of Section 6.1. The Human Rights Act 1998 raises a number of difficulties with interpretation, but to my mind, the questions I've just stated are not among them. As I see it, as a matter of statutory interpretation, these questions admit of only one answer. In such a case, the court cannot hold the trial. When the very holding of the trial by the court would be unlawful, the trial must be stayed. Consistently with its own essential role as a court of law, the court cannot itself knowingly embark on a course of conduct declared by statute to be unlawful, that is improper. Courts exist to uphold the law. My respectful submission, that passage applies exactly to this situation for all the reasons that the upper tribunal in Carmichael explored. Calculation of the maximum benefit in Carmichael, the case of the Carmichaels and consequently in the case of RR, by applying the size criteria and on the social housing scheme making a deduction, is unlawful and was binding authority to that effect. And according to the Secretary of State, in my submission, cannot succeed on a submission that the unlawfulness which is accepted, expressly accepted, should simply be left in place by the tribunal. So
But that seems to be contemplated by Section 3, that if you cannot interpret it, it will nothing that will not affect the validity, or rather, if you interpret it.
Well,
The Act itself.
I've got a point. Can I? Yeah. Now that takes me, I hope, relevantly in answer to your ladyship's question, to another submission by Sir James, which is that it's not open to me to submit that Section 3 is not available to reread the provisions related to the application of the size criteria and say that Section 6 renders their application unlawful. My submission, that's the fundamental mistake that the majority made in Carmichael. There is a difference. Section 3 applies in express terms to all primary and all subordinate legislation. It's an interpretive provision applying to them all. Section 6, as Lady Black put to my friend during the course of argument, expressly states that it's not that in Section 6.1 that it's unlawful to act in contravention of a convention rights, and in Section 2 lays down the Section 6.2 defence, which is not available on the facts of this case. So there's a fundamental distinction between Section 3, which is an interpretive provision applying across the board, and Section 6, but to which there is no equivalent of the Section 6.2 defence, but is a more limited reach. And here, where under Section 6.1, the public authority cannot act unlawfully, the court cannot act unlawfully, unless it's required to do so effectively by primary legislation or by mandated secondary legislation. So my submission that conflation of the approach via Section 3 and Section 6 simply doesn't work. Next point is, I think that my learned friend's scenario, and certainly it was the majority of the Court of Appeal's view as to what should happen, is that my client could appeal Sefton's decision under the provisions of the schedule in the Act to which our case refers, that the tribunal could allow the appeal to the extent of making a declaration that there was a breach of convention rights, but award nothing else. Now, in my submission, that's impossible. The only jurisdiction the tribunal has is to decide on entitlement. My learned friend keeps on saying that as if there's something pejorative about deciding on entitlement. It's exactly the job of the tribunal to decide on the individual's entitlement to an amount of benefit. In this case is about entitlement, not actually about money. It's about one of the rules you use in deciding on entitlement. And the tribunal, if it can't change the underlying decision because of some rule of the sort that the Secretary of State is putting forward, has to dismiss the appeal. There is no jurisdiction to make a general declaration. And that's apparent from the statutory provisions we've referred to in our printed case. It's referred to by Lord Wilson in Matheson at paragraph 49 at MS 961, where he says in terms, no jurisdiction to make a general declaration. So that the view of the majority of the Court of Appeal that this was all acceptable because the tribunal could deal with it by way of a declaration, but otherwise leave the amount of money unaltered, is simply incorrect. Now, next point, taking this shortly, we do say that the job of the FTT on an appeal is to step into the shoes of the original decision maker. I hadn't realised that the relevant provision of the paragraph of the schedule was missing, and well, your ladyship has obviously seen it already, but we'll make sure it gets more generally distributed. The broad approach is discernible from the upper tribunal, yes, it's a tribunal of commissioners actually, case, which is in the bundle at Authorities Bundle 2, tab 22, at MS 1027. And this was a decision of a tribunal of commissioners dealing with the position that whereas previous legislation told tribunals what they could and couldn't do, that hadn't been carried forward into the legislation that applied following the Social Security Act 1998, and I think by parity of reasoning in relation to the housing benefit legislation that we referred to in our case. And so your leaderships of my lords will see, just picking it up at 25, the whole run of paragraphs from 24 to 26 are relevant. But so 4 lines into paragraph 25, the Tribunal and Commission say, taking a simple case for an appeal against a decision on an initial claim, in our view, the appeal tribunal has the power to consider any issue or make any decision on the claim which the decision maker could have considered and made. The appeal tribunal, in effect, stands in the shoes of the decision maker for the purpose of making a decision on the claim. As to the nature of appeal to the tribunal, we therefore agree with the position of Mr. Commissioner Jacobs, etc. And all 3 paragraphs are really reinforcing that approach. And there's a reference in paragraph 24 to the general powers being subject to any express statutory limitation, or subparagraph 10 of, I think it's paragraph 6 or whatever it is such a limitation. That's the general approach. Now, so we are therefore left with a decision of Sefton, which on my case is unlawful. Sefton had no realistic way of knowing that, but it was unlawful. An appeal to a tribunal, it's the job of the tribunal to rectify the unlawfulness. And that's the simple bottom line point in this case. And my learned friend says, well, true it is, the tribunal has no power to consider the issue of DHPs. We agree with that, both for timing reasons and because the subject matter of the appeal is the calculation of the maximum rent. And it's up to the decision makers responsible for recovery of overpayments or designing the legislation that enables recovery of overpayments to deal with all of that. It's not the tribunal's job. The tribunal is limited to its statutory task, which is deciding on the entitlement. Now, unless there's anything else on which I can help, I think it's pretty well 4 o'clock. Those are my submissions.
Thank you very much. I think there are no further questions, and we're very grateful to everybody for all the work that they have put into this. And that includes those who've not been on their feet as well as those who have, because I feel sure that their leaders would acknowledge that they have been of great assistance to them in the preparation of this case. We will now go away and give it our anxious consideration and let you know the consequences as soon as we possibly can. Thank you. Court will now adjourn.